On the 11th of November of 1940, the Royal Navy carried out a raid on the Italian base in Taranto with aircraft carriers. And the aircraft concerned were Swordfish biplanes, and they successfully disabled large elements of the Italian fleet. And that raid was the precursor and model for the Japanese who used it just over a year later to attack a well-known harbor in Hawaii. And the following day, the then Prime Minister, Winston Churchill, got to his feet in the House of Commons. And he did not start with the news of this signal and welcome British victory. Instead, he announced to the House the death of Neville Chamberlain. Neville Chamberlain was, of course, someone who had been a political adversary of Churchill, and he gave quite a well-known speech. And in the course of that speech, he said this: "The fierce and bitter controversies which hung around him in recent times were hushed by the news of his illness and are silenced by his death. In paying a tribute of respect and of regard to an eminent man who has been taken from us, no one is obliged to alter the opinions which he's formed or expressed upon issues which have become a part of history. But at the Lich Gate, we may all pass our own conduct and our own judgments under a searching review. It is not given to human beings, happily for them, for otherwise life would be intolerable, to foresee or to predict to any large extent the unfolding course of events. In one phase, men seemed to have been right. In another, they seemed to have been wrong. Then again, a few years later, when the perspective of time has lengthened, all stands in a different setting. There is a new proportion. There is another scale of values. History, with its flickering lamp, stumbles upon the trail of the past, trying to reconstruct its scenes, to revive its echoes, and kindle with pale gleams the passion of former days. What's the worth of all this? The only guide to a man is his conscience, the only shield to his memory is the rectitude and sincerity of his actions. It's very imprudent to walk through life without this shield, because we're so often mocked by the failure of our hopes and the upsetting of our calculations. But with this shield, however the fates may play, we may always rank in the fields of honour. And that caused me to think about how legal cases are judged, what are right and what are wrong. And it caused me, in particular, to think just how imperfect lawyers are at looking at cases, individual cases, from the point of view of how they are going to be judged in hindsight. We can look back from where we are now and say that decision, a decision of the United States Supreme Court identifying that slavery is wrong, is plainly right. We can look back more recently at other decisions. But in prospect, it is much more difficult. We also, I think, fail to take account of the full breadth of information and of analysis which is available to us in reaching decisions. And that is rarely acknowledged. Now, one of the exceptions to that acknowledgement is a case which I suspect was decided before most members in this room were born, which is the case of Dutton against Bognor Regis Urban District Council in 1972. It is the case where in October 1958, a builder developed a housing estate on land which had formed a rubbish pit. As Lord Denning said in the first paragraph of his judgment, in Bognor Regis there was years ago a rubbish tip. It was filled in and the ground made up so that it looked like the land next to it. You wouldn't have known there was ever a rubbish tip there. The builder built on the rubbish tip. He dug down, he found all the detritus of the relevant material. He put in foundations at the edge walls slightly deeper than would normally be the case, did nothing about the internal walls. An inspector from the local district council came along, passed the foundations, and the house was built. 2 years later, it was sold to Mrs. Dutton, and after Mrs. Dutton moved in, the walls began to move downwards. And there were cracks, and the house became valueless. And in 1964, she brought an action against the building owner and the council. Quite why it took from 1964 to 1971 to get to judgment isn't explained, but things happened more slowly in those days. The judge, after the council called no evidence, found in her favour, and the case came before Lord Denning to decide whether or not there should be a case against the local authority for their negligent failure in relation to the foundations. And he went through all of the various points, and I'm not going to deal with them all, but one of the points that he dealt with was economic loss, and he said that the damage here was not solely economic loss, it was physical damage to the house. If Mr. Tapp's submission were right, it would mean the inspector negligently passes the house as properly built and it collapses and injures a person, the council are liable. But if the council discovers the defect in time to repair it, and he does repair it, the council are not liable. That is an impossible distinction. They're liable in either case. Those words, "that is an impossible distinction," were picked up some years later in a distinguished article in the LQR, and it was submitted by a distinguished former judge of New Zealand who came to this country that Lord Denning was right. And he had a section of the judgment headed policy. And that section of the judgment was longer than any other single section of the judgment. And in it, he said, in previous times, when faced with a new problem, the judges haven't openly asked themselves the question, what's the best policy of the law to adopt? But the question has always been there in the background. It's been concealed between such questions as, was the defendant under any duty to the plaintiff? Was the relationship between them sufficiently proximate? Was the injury direct or indirect? Was it foreseeable or not? Was it too remote? And so forth. And he then went through and he listed the policy considerations which led him to believe that recovery should be granted to Mrs. Dutton. And recovery was duly granted. In 1978, the House of Lords in Anns and Merton effectively extended the ambit of Dutton and approved it with a couple of qualifications. And it was at that point that, or shortly afterwards, that I was at law school and therefore read up on these decisions with interest. 5 years or so after I'd been called, the House of Lords did a volte-face and decided that Dutton and Anns were wrongly decided in Murphy. Despite the fact that the judgment in Murphy is longer, there is no consideration at all of the policy considerations which Lord Denning had set out. It is all by reference to such concepts as whether or not this is truly economic loss, what the ambit of the duty is, and so on and so forth. And thus, from 1991 onwards, we have the position that local authorities have been liable for failures in their inspection to people who are directly injured by their failures, but to no one else. And until the tragic days of June 2017, the number of people who have been directly injured as a result, at least in part, of local authority negligence has been limited. Now let us stand back and do what professional liability lawyers always do, which is construct the but-for analysis, the alternative case theory. Let us look and see what had happened if Lord Bridge and his colleagues had not been in charge, Lord Denning had been allowed to continue, and the law had continued. First of all, would the sky have fallen in? No. Second, would there have been stronger economic incentives for local authorities properly to staff their departments? Answer, I would respectfully suggest, yes. Towards the beginning of my career, I met a man who was the chief architect, when he retired, of the LCC. In his day, the chief architect of the LCC, the London County Council, was an important person. He had many staff. He superintended building. He built, was responsible for the building of large numbers of the council homes which were built in the 1950s and early 1960s. He'd qualified himself before the war, and if you see those four-bedroomed estates, which are still present in large parts of London, you will see that they all have chimneys in them. The drawing test for any aspirant architect of the London County Council was to draw by hand the path of all the various chimneys which went up inside a stack. There were 4 floors, there were 4 rooms, the chimneys were at each corner, and it followed that you therefore had 16 individual flues to draw. And he went down to site, having proudly done his drawing, and presented his drawing to the person who was constructing the site, the brickie, who looked at it, smiled and said, "There's only one way to do that, mate, and we know what that is." In other words, the drawing was useless. But nonetheless, the point was these were important professional people. Who now can honestly say that the borough surveyor of any of the London boroughs, or for that matter, the GLA or anyone of that, operates an important part? They have been starved of cash and they have been starved of liability, and that has been no doubt in large part because it has probably been cheaper to pay for their consequences than otherwise. There is a wider point, which is about the confluence of the law and of regulation. If the 19th century was the law of, was developed to the law of commerce, the law of contract, and the 20th century was developed to, at least in the start, the growth of the tort of negligence, we live now in the era of regulation. We have regulators all over us. What is the proper role of regulation when allied with the law? I would respectfully submit that regulation, first of all, should be imposed in circumstances where the market is otherwise unlikely to do its job, and that would certainly include building inspectors and the like. The first London Building Acts were instituted after the Great Fire of London for good reason. You cannot trust the market. But having instituted regulation, why do you not have the forces of the law being in tune with regulation? What more can make it more likely that inspections are going to take place and take place properly than that the consequences of mistake are visited not merely by a tap on the shoulder, but by economic consequences? And that failure, that dichotomy has been present in large part in England and Wales since the House of Lords decided in 1991 to overturn Dutton. My own suggestion would be that if you look at confident societies, if you look at Britain in the 19th century and indeed the early part of the 20th century, if you look now at America, they are not actually afraid of expanding areas of law. What happens with economic activity and economic growth is you get people trying to do things differently and trying to restrict things. By contrast, we have been in a period of, as it were, legal recession. We first of all get restrictions on economic loss, then we get the invention of a notion of scope of duty. It's not the subject of this lecture. but I still have no better understanding, really, of what scope of duty means, despite what is said by the Supreme Court in Grant, than I did after the decision in BBL. It is one of those occasions when at some point a boy is going to say the emperor has no clothes, and the Supreme Court is going to say, do you know, you're right. I don't think that doctrine does have any clothes. But I digress. The point that I am making is that economic activity, the law and regulation should go hand in hand, and we should not be fearful of the consequences when it does so. And I venture to suggest that one of the consequences of Grenfell will be a recognition, or to use Churchill's more flamboyant word, the history with its flickering lamp stumbles along the trail of the past, trying to reconstruct its scenes and so forth. They will be reconstructed and they will be looked at in a different light. Now we get to the actual subject of this talk. I've come in off a long run. Thornhill is a terrible decision. It's a terrible decision in prospect, let alone in retrospect. It is a decision which encourages the very worst sort of behaviours. It will, in due course, be recognised to be wrong. One does not need the flickering lamp of the past to look at that decision. I am, of course, obliged to declare an interest. I'm very grateful that my premiums did not go up as a result of Mr. Thornhill having been found to be liable. But boy, did he try and be liable. You first of all take part in the devising of a scheme, a tax avoidance scheme. Now, let's just look at the useful functions that tax avoidance schemes play in this country. They fund accountants. They fund members of the tax bar. They cause very large amounts of printer's ink to be developed in providing endless manuals. They provide gainful employment for Her Majesty's inspectors of taxes, who, as soon as they are properly qualified, go and work for Pricewaterhouse or one of their competitors. I can't think of anything else. I can't think of any other reason why the promotion of tax schemes is an economically valuable activity. Now, of course, one can say with some vehemence that most of these tax schemes come about because some lunatic minister has decided to tamper or fine-tune or generally muck around with the tax legislation. Why Tony Blair thought that tax schemes for the benefit of the film industry should have a special status, which means the rest of us have to pay more tax if we're not in the film industry, but if you are in the film industry you pay less, who knows? Who only knows? But even Tony Blair or Gordon Brown, acting at their worst, did not imagine that what would then be done, that's possibly because they haven't been around enough accountants and lawyers, but that's by the by, is that you try and remove any point in the actual economic incentive being provided in order to have some scheme which can be sold as if it is, in truth, an investment. So we start off with the proposition that the activity we are discussing is not saving people from cancer. It is not even developing land. It is not even doing the promotion of some legitimate investment scheme. It is the promotion of a tax avoidance scheme. The barrister concerned is involved at the ground floor. He is not some independent, dispassionate advisor. He's looking at the setting up of the scheme. He knows that in order for the scheme to succeed, it's got to be sold. And it's got to be sold by an information memorandum or a prospectus. And in order for it to be sold by an information memorandum or a prospectus, it has to be made to look as foolproof as possible. Now, I do not know how many of you here have invested in tax schemes. No doubt some of you have, no doubt possibly some of you, I'm not talking incidentally about putting money in pensions, no doubt some of you possibly have made some money, although I don't think I've ever met anyone who's made any money from the selling of these schemes, at least in the long term. You are, and this is undeniable, trying to sell to a gullible population. This is, however, nothing new. Back in the 19th century, when prospectus liability was developed, the whole point of trying to sell for schemes which are taking place in Guyana or Africa or other parts of the world was to sell to a gullible, capital-happy population. They didn't, of course, have to avoid income tax because there wasn't any, but they were nonetheless keen to improve their results. So you're selling to the gullible. I accept that. But you do also need to get round their natural inclination. So what do? You don't advise that on the one hand this and on the other hand this, and on balance you take the view, having taken into account all of the relevant considerations, that the tax scheme should succeed provided X, Y, and Z takes place. Now, many of you are no doubt recipients of barristers' opinions. Some of you, no doubt, are those annoying clients who say that they want to have a percentage chance of success on litigation. And when your barrister tries to avoid the question by sending it back to you, saying that it all depends on X or Y, they say, yeah, but give us the percentage chance of success. And so you send back, well, I think it's 50.5%. Or some other weasel expression of opinion. Sometimes, if you're really feeling confident, and I have been accused every so often of being a relatively confident member of the bar, you say that it is your firm view that something should succeed. You do, however, even in those circumstances, be fairly careful to caution about risks. Mr. Thornhill, of course, didn't do any of that. His view was unqualified. And as the Court of Appeal eventually found, somewhat, I have to say, less obviously than it should have done, he was negligent in that respect. He'd been let off by Mr. Justice Zaccaroli at first instance for reasons I still can't understand, on the basis that there was some kind of independent duty to warn as compared with the duty to give advice in the first place. But in the Court of Appeal, the court decided that giving unequivocal advice in the context of this scheme was negligent, as it plainly was. So you have a negligent barrister who's involved at the grounds up, and then who approves the terms in which his own advice is put to the punters, to the individuals. And the terms in which his own advice is put are similarly unequivocal, and the investors are told that if they want to, they can have a copy of Mr. Thornhill's opinion. And he doesn't bother to say anything to the effect that no one other than his clients can rely on the advice. Now, just pause there. Those of you who are members of the bar, indeed those of you who are members, you are being told that your opinion is going to go out the door to an unknown number of people. Do you or do you not, in those circumstances, put a qualification in relation to your advice? He doesn't bother. Of course, if he had done that, it substantially increases the prospect that the investors concerned will take their own independent advice. At which point, of course, the awful possibility might occur that they might not sign up to this bonking, barking mad scheme, which is being sold like snake oil by a snake oil salesman, dressed up as a member of the barrister's profession. Now, I didn't quite open the appeal in the way that I've opened it to you. I did, however, say, as my first point, that Mr. Thornhill was not acting in the way that a barrister ordinarily acted when allowing his advice to be touted around and supplied to potential investors. And that submission was one from which I certainly never resiled, and which, frankly, in my respectful estimation, was plainly right. The submission was duly transcribed and set out in the judgment by Lady Justice Simler. She accurately recorded at paragraph 85 as the first of my submissions, the judge was wrong to treat this case as raising a question whether an advisor on one side of a commercial transaction owed a duty of care to the opposing party. Mr. Thornhill was not acting as an advising barrister in any ordinary sense. He was intentionally making himself part of the sale process in relation to its most critical aspect. As the judge found, there was no conflict of interest. What that means is that his interests were precisely aligned with the sellers who were putting his advice in the prospectus. When, however, she starts her discussion, she starts off by saying, so far as the applicable legal principles are concerned, there was little controversy. As a general rule, a lawyer owes a duty of care to the party for whom he's acting, but generally owes no duty to the opposite party. What's that got to do with the price of eggs in relation to the submission I was putting? When you submit he's not acting as a barrister, you expect the Court of Appeal to at least do you the courtesy of dealing with the submission, of explaining why it is that Mr. Thornhill deciding to flog tax investment schemes, tax avoidance schemes, is part of a barrister's ordinary function. Of course, if you start from that prospect, it's a bit like on the other side when I knew that we had won in the Supreme Court in BPE and Gabriel and read the first paragraph of Lord Sumption's decision in that case, which framed the question precisely as we wanted it to be framed. But if you start from the proposition that you're dealing with a barrister in exceptional circumstance, then you're likely to receive a different conclusion. Now let's just test that a little bit. Where does this take us? Prospectuses are at the heart of selling investments in the City of London and indeed in the United Kingdom. There is a well-known process by which each sentence of a prospectus has to be vouched for and backed off against appropriate proof. So if, for example, you are selling a property investment and you are relying on a valuer's assessment of the relevant valuation evidence, you have to ensure that the valuer concerned has indeed given you the appropriate advice which is being reflected in the prospectus. You have to ensure that any qualifications are accurately put forward. You have to ensure, particularly, as to whether he is or is not accepting a duty to anyone other than his own clients, with the consequences that that faces. The same is true for any other aspect of putting a prospectus forward. So this is not, as would appear to be the case, a barrister's protection device. It has much wider applications. Secondly, let's think about the role of regulation. It was the gallivanting nature of prospectuses in the 19th century, by reference to interesting adventures in trade all over the world, which led directly to the incorporation of prospectus provisions within the Companies Act. In other words, those prospectus provisions can be traced through Parliament and public policy accorded with them. Those prospectus provisions continue, and they were enhanced in relation to most, but not all, investors. And when I say most, but not all investors, the point is that there are still unregulated collective investment schemes. The judge, giving the leading judgment, said this in paragraph 96. I start with the regulatory and commercial context. The scheme was an unregulated collective investment scheme, as the IM made clear. It did make that clear. That meant it wasn't authorized or otherwise approved by the Financial Services Authority. That's also true. It would never have been authorized or approved by the Financial Services Authority. It couldn't be promoted or marketed directly to the general public, and the IM itself was only directed at investment professionals. The IM explained that investors didn't and wouldn't have the protection of the FSMA or be eligible for any compensation scheme. Mr. Stewart relied by analogy on provisions in successive company acts in showing what the result should be at common law in a prospectus case such as this. The provisions included Section 84 of the Companies Act 1908, Section 37 of the Companies Act 1929, Sections 41 and 43(1)d of the Companies Act 1948, which added experts who consented to the use of their reports in a prospectus to the class of those liable to persons subscribing on the faith of the prospectus, with the statute of defence if they could prove the existence of reasonable grounds for believing their statements to be true. I regard this argument as untenable. The regulatory backdrop is one in which Parliament has determined expressly that the statutory protections available for regulated schemes do not apply. Now, just let's unpick that. What the judge is saying is that we've gone backwards since 1929 in relation to these schemes. That as a matter of policy, it has been decided that protections which were previously afforded by provisions whereby experts had to stand behind what was being put in prospectus, experts such as Mr. Thornhill, they've now been written out backwards because of the FSMA provisions. Now, I mean no disrespect to the qualities of the members of the Court of Appeal, but that is bonkers. It really is bonkers. Which person in the real world is looking at that and thinking, yes, that makes sense? The protections which are available in 1929 are obviously far greater than those which we would expect to have available and applicable now. The reason why the Court of Appeal decided that despite the absence of a disclaimer, despite the unqualified terms of the advice, the fact that the prospectus advised clients to obtain their own tax advice meant that it wasn't reasonable to expect reliance on the terms of Mr. Thornhill's advice. Now, I do not need to go into the details of what was said. Put it this way, if that is what they'd intended to say, the prospectus could have been an awful lot clearer, and they could have made it plain that there was no reliance being placed on Mr. Thornhill's advice. And frankly, if you look at the details, I suspect you will concede that that is well-founded. But take it one stage further. You have got a man who is being touted as the former head of one of the leading tax chambers. He's being promoted as the tax guru in the investment memorandum. And you're being told about the unqualified nature of his advice. What is the purpose of that other than to discourage the necessity of people relying and taking upon their own advice? Where do you see that dealt with by the Court of Appeal? Answer, you will look in vain in the judgment for any such considerations. Now let us stand back and with Lord Denning look at the policy considerations behind this. Is the sale of dodgy tax schemes in the public interest? Oh, sorry, just for the avoidance of doubt, incidentally. The tax scheme doesn't work, it's been found not to be worked, and all of the investors who put it in have been served with notices, etc., in respect of it. I mean, in other words, standard fare for anyone who goes investing in icebreaker, film schemes, and so forth, the modern equivalent of the perpetual motion machine. But you know, leaving aside that small little detail, is this in the public interest? Is it in the public interest that barristers or other advisors should be held not to owe duties in respect of unqualified advice to investors? What's that going to do to the people who invest on this scheme and find out 7 or 8 years later that their arrangements have been made on a false basis? Now, it may be that people won't be crying in the streets for these people. They all said, well, there are other and more deserving people, possibly people who've bought flats with flammable material on the outside. But leave that. Does it make society a better place? I leave you to answer your own. Second, does one feel any sympathy for Mr. Thornhill? Could he, if he wanted to, have put in a disclaimer, a clear disclaimer? Yes, he could. Could he have been careful? Yes, he could. Did he make his livelihood from saying yes to investment schemes? That admittedly wasn't in evidence, but the answer is yes. That's what he did. Now, then look at the repercussions of this. And let's look at the repercussions for London, for the United Kingdom. Now, we've already got a bonkers government who's decided to cut off the capital of Europe from Europe in terms of that. So we're already under a handicap in terms of that. But we have got a commercial fund of expertise and excellence. Have we aligned regulation in London with the legitimate aspirations and expectations of investors? Have we? Heck. Have we got anything like as comprehensive a system of investor protection in terms of the application of the general law as they have in our competitive countries, in particular New York? Have we? Heck. Has any of this been considered by Her Majesty's learned judges when actually thinking about what the policy implications of this are? No, it has not. Why has it not been? Lord Denning was looking at it back in 1972, 52 years ago. He was calling a spade a spade. Why is it not being done here in this country now? I'm going to move on in a minute from what you will understand is a classic rant of the person who has lost an argument he thought he ought to win and has been denied permission to appeal, but also has the certainty given only to barristers that they're definitely right and there is no possibility of being wrong. But before I do so, I do just want to look and see what the actual implications of this are in terms of economic incentives. Is there an economic incentive on barristers advising in relation to tax schemes to be careful? No. Are you then reliant entirely on their professional good sense and sense of honour? Yes. Will those who are not prepared to be categoric get any work in this field? Answer, no. What are you therefore doing as to the likelihood of encouraging future cases of this very sort? And in that context, I don't know how many of you follow Dan Needle on Twitter, but I commend doing a search in relation to him for the last 2 or 3 days for Mr. Needle's views in relation to Mr. Thornhill currently acting in relation to another scheme. Now, as I said, it's an ill wind which brings no one any good, and I've not no doubt that in due course there will be some members of this room who are gainfully employed as a result of it. And I am the last person to say anything about the merits or otherwise of being gainfully employed as the result of one's clients. But from society's point of view, what on earth is the point of that? So, ladies and gentlemen, I commend the decision in McClean and Thornhill to you. I suggest that in due course it will be held to be wrong, and I suggest that in due course the considerations that I have put forward will be proved to be right. The second decision, which I'm going to speak about, albeit much more briefly, is the decision of the Court of Appeal in Ashraf against Lester Dominic solicitors. Now, this case had a distinguished panel on it. Not, of course, that the panel in the other case was not distinguished, not least as the current Lady Chief Justice was the member who came closest. She could have come a lot closer in my view, but she came closest to expressing some dissatisfaction. I can't help think she might have had other things on her mind. I'd have written the dissenting judgment for her, but anyway, that's by the by. Lord Justices Arnold Newgee and Sir Christopher Lloyd, with Lord Justice Newgee giving one of his characteristically measured judgments. Now, that is a case where a solicitor was acting as a solicitor. There was no doubt about that. And the only question in that case was whether in a particular small respect it was unquestionably the case that he could not be found to be owed a duty to the other side. And in one small respect, Lord Justice Newgee, for reasons which, in my consideration, are entirely justified, held that such a duty could not be ruled out. Now, by contrast with the decision in McClean, this was therefore a case where it is entirely proper to start off with the proposition that generally barristers and solicitors owe no duties to persons other than their client, and to go through the exceptions. You are not begging the question by doing that in the case of Ashraf and Lester Dominic. It is also the case, self-evidently, that it is appropriate on that basis for the law to develop on an incremental and a case-by-case analysis. So, in respect of Ashraf, I say that at least in 2023, in this field, or in this allied field, the Court of Appeal got one decision right. I want, if I may, to allow you to ask any questions, but before I do so, I do just want to stand back and reflect just a little bit more on how I would suggest it is appropriate for difficult policy decisions to be taken. It is possible in the Supreme Court to adduce a wider range of evidence than is the case in the lower courts. It is also the case that in particular fields, competition is one obvious field, the courts do regularly receive economic analysis and considerations which provide the backup to the decisions they make. Lawyers tend to think, however, that in relation to such matters as duties of care, they do not need such assistance. You will find somewhere, goodness knows where, I think it's on the internet and I think you've got some links to it, a short version of the talk which I've given, stripped of any possible defamatory content, so as to ensure any action against me is only for slander. And you will see that in it, I start from what a duty of care actually involves. And at heart, a duty of care is a duty imposed by law because of a particular factual situation which the court considers ought to be remedied. Now, how that has developed has, of course, gone through all the cases with which you are familiar and some of which we've discussed today. But that is the essential consideration that you are looking at. And in my submission, I would suggest that in looking at that, it is of profound consequence to try and consider what the economic consequences would or might be in relation to particular decisions. Let us take Murphy and Brentwood. It is said by those who have more experience than I do, I remember Sir Sidney Kentridge saying this, that it's very important to know the age of the judges that you're appearing in front of, because the cases they will actually know will be the ones which were current at the time of their finals. Some others, some of the better ones, may have a nodding acquaintance with what's happened in the 40 or so years since, but they're likely to be fairly hazy as to the actual details. And he said, having done his second case in the Supreme Court in his 90th year, I find it more difficult now to find out what was current when they were at university. But his advice was to look at that. And if you look at that and consider what was current, what was then under discussion when people like Lord Bridge were at university, you realize that decisions which were being taken in the 1930s were extremely relevant, and that concepts such as pure economic loss, what the proper boundaries of the decision in Donoghue and Stevenson were, and so forth, were very much up for debate. My suggestion, ladies and gentlemen, would be that we can do a little bit better than that in the 21st century. We could possibly have judges who are at least not primarily lawyers. We could accept submissions which are not limited to matters of law. We could stop pretending that we don't take policy decisions. And that, ladies and gentlemen, is the thought with which I would like to leave you. I'd be very happy to take any questions, or indeed, given what I've dished out, any trenchant criticism from anyone present in the room.
So one question, trends, the Thornhill judgment, does that reflect a trend?
I think it reflects a general trend of restriction in relation to the applicability of duties of care. And the other major area of trends is the scope of duty matter. If you talk to lawyers who are quite close to us in terms of their background and training, even if they do come from Australia, they have a great deal of difficulty with where we have gone and are going in relation to duties of care and negligence. The same is true with knobs, bells and whistles on for people from New Zealand, and although they have a slightly different take and attitude to people from Canada as well. And I think that if you have the three largest major jurisdictions sounding in one form or another warning bells, that is something with which we would be well advised to take note. Anyone else? I see that Ahmed Salim from the Bar Mutual left before the talk. I can't imagine why. Well, thank you very much. I'm very sorry for having finished slightly early, but I do make clear I did start on time, so that's my excuse.